Good morning, everyone. Welcome to Assembly Judiciary. Welcome to those that are here in Carson City, as well as anyone there in Las Vegas participating, and of course, those watching over YouTube or our Nellis station. With that, Committee Secretary, please take the roll.
Assembly members Cole. Here. Dahlia. Here. Gonzalez. Here. Gray. Here. Hanson. Here. Hardy. Here. LaRue Hatch. Marzola.
Present.
Moore.
Here.
Nadeem.
Present.
Orant Liquor.
Here.
Roth.
Here.
Urick.
Here.
Chair Miller.
Here. And with that, please mark Assemblywoman LaRue Hatch present when she arrives. So just a few reminders as we begin. Please remember to turn down the electronics on your computer so that it's not disruptive during the meeting. We will have public comment at the end of today's meeting. We ask that anyone making public comment or testifying on any bill, please keep their remarks to 2 minutes each. This is my computer, excuse me. Yeah, I will turn it off in a moment. We ask that you please keep your remarks to 2 minutes each. Anyone presenting a bill or testifying or making public comment, we also ask that you say your name and that you spell it so that we have it correct for the record. With that, again, please remember that you will see members using their computers and such, but that's not a sign of distraction or disrespect. Please understand it's a sign of members researching and reading the bills and such. With that, we do have 3 bills today. We will begin with Assembly Bill 119. Assembly Bill 119 revises provisions relating to paramilitary activity. This bill, while it is sponsored by Speaker Yeager, Assemblymember Roth will be presenting on his behalf. And so, Assemblymember, I'll give you a few minutes to get settled, and you have a co-presenter. And so, whenever you're ready, please both introduce yourselves, state your name. Again, we ask with bill presentations that you keep your presentations to 15 minutes. And whenever you're ready, please proceed.
Thank you. Good morning, Chair Miller, Vice Chair Marzola, and members of the Assembly Judiciary Committee. My name is Erica Roth, E-R-I-C-A-R-O-T-H, and I'm proud to represent Assembly District 24 in Washoe County. Thank you for the opportunity this morning to present Assembly Bill 119 on behalf of Speaker Yeager, which addresses paramilitary activity in Nevada. Today, I'm joined by Mary B. McCord, Executive Director of the Institute for Constitutional Advocacy and Protection, otherwise known as the ICAP, and a visiting professor of law at Georgetown Law Center. First, I want to make clear what this bill is not about. This bill does not create any new crime, nor does this bill infringe on long-established Second Amendment protections. Instead, Assembly Bill 119 equips law enforcement with the tools necessary to investigate and prevent paramilitary activity before it escalates into potential violence. Additionally, it establishes a civil remedy for individuals who have been injured as a result of such activity. In recent years, we have witnessed a troubling rise in extremist ideologies and anti-government sentiment across the country. The spread of violent rhetoric and the increasing visibility of armed groups have created a climate of fear and intimidation in some communities. As documented by the Center for American Progress, violent words often lead to violent crimes, and it is important that we take steps to address threats proactively. Nevada is not immune to this trend. As noted by the ICAP, groups of armed individuals engaging in paramilitary activity or law enforcement functions without government authorization are acting as unauthorized private militias and are illegal in all 50 states, including Nevada and Delaware. Furthermore, recent reports have highlighted links between militia groups and public officials in our state, raising concerns about the potential for undue influence and abuse of power. These groups often engage in behaviors that show their intent to act as private militia. This includes wearing military-style uniforms, tactical gear, or identifying insignia, and additionally wielding firearms or other weapons. Assembly Bill 119 is not about infringing on anyone's constitutional rights. Instead, it is intended to provide law enforcement with the necessary tools to address this threat effectively. With the chair's permission, I will now hand it over to my co-presenter to provide further details on the work of the Institute and walk you through each section of the bill.
Thank you, Assemblymember Roth, and good morning, Chair Miller, Vice Chair Marzola, members of the committee. I'm pleased to testify today in support of Assembly Bill 119. My name is Mary McCord, that is MaryMccord, and I'm the Executive Director of the Institute for Constitutional Advocacy and Protection, which we call ICAP. I'm also a visiting professor of law at Georgetown University Law Center, as Assemblymember Roth explained. Prior to helping found ICAP in 2017, I spent most of my career at the U.S. Department of Justice, most recently as the Acting Assistant Attorney General for National Security, and before that, the Principal Deputy Assistant Attorney General for National Security between 2014 and 2017. Previously, I was an Assistant U.S. Attorney in the U.S. Attorney's Office for the District of Columbia for nearly 20 years, culminating in being the Chief of the Criminal Division. At ICAP, we have developed an expertise in legal options to counter paramilitary activity, including bringing successful litigation in state courts in both Virginia and New Mexico to obtain injunctions against private militia activity in those states. We've also consulted with local and state officials, law enforcement, and civil society across the country on how to protect public safety while preserving constitutional rights. This includes legal options during demonstrations and protests, and also during governmental proceedings, state legislative sessions like this one, local board meetings, and at or near polling places. We have seen that unlawful paramilitary activity is a danger to public safety and law enforcement, regardless of the ideology motivating it. AB 119 is consistent with the U.S. Constitution as well as the Nevada State Constitution and statutory law. It is a viewpoint-neutral bill that applies to conduct that is not protected by the First or Second Amendments. The bill does not prohibit freedom of expression, freedom of association, or lawful possession and carrying of firearms for self-defense. Instead, the bill prohibits armed paramilitary activity by persons who are part of or acting on behalf of or in furtherance of the objectives of a private paramilitary organization. My testimony proceeds in three parts. First, I will talk about the extensive history of regulation of private paramilitary activity in this country. Second, I will discuss Nevada's current law that prohibits paramilitary activity. And finally, I will explain how Assembly Bill 119 fills gaps in existing law by providing a civil enforcement mechanism for preventing paramilitary activity that threatens democratic processes and usurps the role of law enforcement. So first, a well-regulated militia, referred to in the Second Amendment, has always meant regulated by the government, even before the country's founding. Early state constitutions made clear that the militia, made up of able-bodied men between certain ages, were always to be strictly subordinate to the civilian governmental control. By the time of the Constitutional Convention in 1787, the founders included the militia clauses in the U.S. Constitution to ensure that only Congress would have the authority to provide for the organizing, disciplining, and calling forth of the militia. Congress thereafter exercised its power under the militia clauses to create the National Guard system and to also authorize the states to maintain their own defense forces outside the National Guard system. The U.S. Constitution gives no authority to private individuals to form their own private militias or paramilitary organizations outside of government control. Second, the Supreme Court has been clear since 1886 that the Constitution does not protect private paramilitary organizations. In a case called Presser v. Illinois, the Supreme Court upheld a state anti-militia bill that prohibited bodies of men from associating themselves as military units or military companies or parading or drilling with firearms. The court held that the First Amendment does not provide a right voluntarily to associate together as a military company or organization outside the control of the government. The court further explained, military organization and military drill and parade under arms are subjects especially under the control of the government of every country. They cannot be claimed as a right independent of law. Under our political system, they're subject to the regulation and control of the state and federal governments, acting in due regard to their respective prerogatives and powers. The court further held that prohibitions on private paramilitary activity do not infringe on the right of the people to keep and bear arms, and that states must be able to prohibit private paramilitary organizations as necessary to the public peace, safety, and good order. In 2008, the Supreme Court, in the first case ever to recognize an independent right to bear arms for self-defense, restated what it had made clear in Presser, that the Second Amendment does not prevent the prohibition of private paramilitary organizations. That case, District of Columbia versus Heller, was written by Justice Scalia, who indicated that no one even advocating for an individual right had considered that private paramilitary organizations would be protected by the Second Amendment, and indeed they are not. Third, the paramilitary activity is unlawful in all 50 states. 48 states, including Nevada, have a provision in their state constitutions that provide the military shall always be strictly subordinate to the civil power. 30 states have an anti-militia law. Most of them, including Nevada's, are nearly identical to the law upheld by the Supreme Court in 1886. More than 25 states have anti-paramilitary laws that generally prohibit teaching, demonstrating, instructing, training, or practicing in the use of firearms, explosives, or techniques capable of causing bodily injury or death for use during or in furtherance of a civil disorder. A dozen states, including Nevada, prohibit falsely assuming or engaging in the functions of law enforcement officers or public officials. And at least 9 states have laws that ban wearing uniforms that are similar to the uniforms of the U.S. military. Now, as I mentioned, the second point I want to talk about is what do Nevada's current laws provide? Although the Nevada state constitution guarantees the people the right to bear arms for security and self-defense, it also makes clear that the military shall be strictly subordinate to the civil power. The Nevada Constitution further bestows upon the governor the power to call out the militia, to execute the laws of the state, or to suppress insurrection or repel invasion. A Nevada statute prescribes that the governor is the commander-in-chief of the militia of the state. By statute, Nevada's militia is composed of the Nevada National Guard and, when called into active service by the governor, reservists to the Nevada National Guard and any voluntary military organization licensed by the governor. Only the governor has the power to license a voluntary military organization. Private individuals have no authority to form their own militias or to engage in the functions of law enforcement without authorization. Indeed, Nevada law makes it a crime for any body of individuals other than municipal police, university or public school cadets or companies, the militia of the state or troops of the United States to associate themselves together as a military company with arms without the consent of the governor. Nevada law further criminally prohibits such groups from associating themselves together as a voluntary military company or voluntary military association to drill or parade with arms in any city or town in Nevada without license of the governor. Finally, it's a crime for any person to willfully exercise any of the functions or perform any of the duties of a public officer without having duly qualified therefor under Nevada law. Nevada also heavily regulates law enforcement and security services under Chapter 648 of the Nevada Revised Statutes and requires a license to anyone seeking to provide security services. Moving on to this particular bill, AB 119 would provide a more effective enforcement tool against the continuing threat of violence from armed paramilitary organizations by allowing the state to seek an injunction against conduct that endangers the public and law enforcement without regard to the ideology that may motivate that conduct. So although Nevada law currently criminalizes certain paramilitary activity, as just discussed, the language of existing law and its lack of a civil enforcement mechanism have limited its effectiveness. Assembly Bill 119 would not criminalize paramilitary activity. Instead, it would create a civilly enforceable prohibition on specific types of armed activity by individuals acting as part of or in furtherance of the objectives of an unauthorized paramilitary organization, with a focus on actions that threaten public safety and civic life. The categories of unauthorized armed private paramilitary activity that could be enjoined include public patrolling, drilling, or engaging in techniques capable of causing injury or death, substantially interfering with government operations, assuming the functions of law enforcement or a state, local, or federal government official, preventing or attempting to prevent another person from engaging in conduct they have a right to engage in, such as protected free expression, petitioning the government, and voting, or training to do any of these activities. Importantly, the bill also includes exceptions for activities such as historic reenactments, government sanctioned training, and government authorized security services. The bill defines private paramilitary organization as an organized body of 3 or more persons associating under a command structure for the purpose of functioning or training to function in public as a unit of combat, combat support, law enforcement, or security services. Key to AB 119 providing a more effective alternative to existing law, the bill includes a civil enforcement mechanism by which the Attorney General may seek injunctive relief against those engaging in the proscribed paramilitary activity, as well as a private cause of action for individuals harmed by private paramilitary activity to seek money damages and/or injunctive relief. Thank you for the opportunity to address the committee, and I look forward to your questions.
Thank you so much, Chair. And Professor McCord, if you could just very briefly walk through each section of the bill so that the committee can follow where those changes are made.
Sure.
Sorry, Erica Roth for the record.
I'm sorry, Mary McCord, also for the record. So the Section 1 and Section 2 provide for the Attorney General to investigate when there is any alleged paramilitary activity that may violate the statute. This would include issuing cause to be served upon a person with an investigative demand that would allow for appearance and examination under oath, written interrogatories, and production of documents. Again, that is when there are reasonable grounds to believe that the subject of the investigation would violate this paramilitary activity law. Section 3 and the sections thereafter, Section 3 gives the Attorney General the authority that I was just referring to, an authority where the Attorney General has reasonable cause to believe that a person or group of persons has engaged in or is about to engage in the prohibited conduct, could seek injunctive relief in a court of law. And the idea here, of course, is so that you don't have to wait until after the activity has occurred if there is enough evidence to have a substantial reason to believe it is about to occur. Let's say before a planned First Amendment rally or protest or demonstration, or let's say before a legislative hearing or a meeting of a school board or a county board, if there is that type of reason to believe paramilitary activity may disrupt those proceedings, that is something that injunctive relief could be sought for. And similarly, Section 4 provides a private person with the authority to seek in court an injunction or to seek money damages if that person has been injured by conduct that violates the law. Section 5 goes on to describe the prohibited conduct, and that is the conduct that I mentioned in my opening presentation. That says that while armed with a deadly weapon, anyone who is acting on behalf of or in conjunction with a private paramilitary organization, as defined later in the bill, while armed with a deadly weapon, publicly patrolling or drilling would be prohibited, and while armed with a dangerous weapon or a deadly weapon, publicly engaging in conduct capable of causing physical injury or death, or substantially interfering with the operations of a governmental entity would be prohibited. Now, the next prohibited activities, the initially enrolled draft of the bill did not require that they only be prohibited while armed. I have suggested, and I believe an amendment may be pending or will be introduced that would require, again, this while armed with a dangerous or deadly weapon to also apply to these other categories of prohibited activity that I'm about to describe. That would include unlawfully assuming or exercising or asserting the functions of a peace officer or law enforcement officer or state or local or federal government official. That would also include interfering with or attempting to interfere with the legal rights of another person, and that could be by trying to prevent or attempt to prevent them from engaging in conduct they have a right to engage in. Those are things I was mentioning before, like free expression, free association, petitioning their governments, appearing to testify at hearings like this, etc. It would also prevent, again, with an amendment, armed paramilitary activity that causes or attempts to cause another person to engage in conduct that they have a right not to engage in. And finally, it would prohibit training to do any of these things that are prohibited conduct. The idea here is to be completely viewpoint neutral, focus on conduct that presents a threat to public safety, that is a threat also to people's participation in democratic processes, and that is closely tied to the history of governmental regulation of private paramilitary activity in this country, going back to even before the founding. Section 6 has a number of exceptions, some of which I mentioned, historical reenactments and other sort of
Professor
state
McCord,
government.
I'm sorry
Yes.
to cut you off. I think we're running up on time. So just for
Okay.
some brevity, I know that the committee was provided with the amendment, and we're more than happy to continue to answer any questions. Before we turn it over to questions, I just want to briefly, I have been in contact with the public defender's offices. They have made a few suggestions just regarding really setting out that lawful expression under the First Amendment and then Fifth Amendment protections are very clearly enumerated. We have no problem with that. The purpose of this bill is to allow for investigations and prohibition of already currently unlawful activity. And then I think with that, we are ready for questions if the chair wishes.
Yes, we are. Thank you so much for your presentation, and thank you for being with us today on Zoom. With that, our first question is from Assemblyman Urich.
Thank you, Chair, and thank you for that presentation. I really appreciated your focus on conduct, right, and threats to public safety, which I think are going to be paramount in a bill like this. My question comes as I look at language and potential vagueness that might be concerning is if I look at subsection 5B, it refers to publicly engaging in conduct that's capable of causing physical injury. And my concern is that any open carry might meet that threshold. And so if this was brought forward and the Attorney General had to investigate, courts are having to delineate, can you help me understand, like, what will courts use to draw or distinguish a line there between legal open carry demonstrations and what would be prohibited paramilitary activity?
Erica Roth,
Yes,
for the
thank you
record.
for-
Sorry, I'm just going to jump in real quick, and I just want to make sure, is that from the proposed amendment, the conceptual amendment? It's in the bill. Oh, okay. I'll turn it over to Professor McCord.
Yes, thank you, Mary McCord, for the record. Thank you for that question. So part of that language is taken from the language of existing statutes in more than 25 states, which has been upheld by courts. But more specifically to your question, it would not just be people who are open carrying in a demonstration, which, as you have indicated, if you have a firearm, of course, there is a capability of causing injury there. It would be people who are also acting as part of a paramilitary organization. And that is defined as a group of 3 or more people acting under a command structure as a combat or combat support unit. So there'd have to be that sort of organization and projection of the ability to use force against others. And I think it would depend then on what types of activity that group is doing. So simply having a First Amendment rally while people have sidearms would not be able to fit within that definition.
Thank you for that. Our next question is for Assemblymember Gray.
Thank you, Madam Chair. So what about groups, in your estimation, would this break the law? Groups that actually train on private property, a lot of them are en masse, they train for protection of their private property, draw, stop, drop, and roll shooting scenarios, active target scenarios. You know, if my neighbor is offended by that and they turn me in, would the Attorney General still have grounds to investigate?
Assemblymember Roth, do you want me to address that?
Erica Roth, for the record. Yeah, I think Professor McCord would be best suited to answer that question.
Thank you, Mary McCord, for the record. So the only training that would be prohibited is training to do the other areas of prohibited conduct in public, right? So if the training that is taking place on your property or someone else's property is about self-defense and defense of your property, the types of things that you were indicating without any intent to go as, again, part of a paramilitary organization while armed and engage in any of the prohibited conduct in public, then that is not something that should be subject to investigation.
Thank you.
Thank you. Our next question is from Assemblymember Cole.
So this question kind of piggybacks on your response there. So I'm just looking at the definition of private paramilitary organization. It means an organized body consisting of 3 or more persons who associate under a structure of command for the purpose of functioning or training to function in a public place as a unit of combat support, law enforcement, or security services. And so I'm looking at that, and I think what my colleague just said would fit into that definition because it's an or, because it's not associated necessarily with combat or combat services. And I'm looking at it from the perspective of ranchers who have a very large land area and they're trying to work on bringing cattle in or whatever they're doing. And they could be under the security services perhaps.
So again, I think the distinction there is, are you protecting your own property and training for that? And I don't think that would be covered here. Security services, as I indicated, are regulated under Nevada law currently. So to provide those services other than sort of, at your own home or your own ranch or your own property requires licensure, examinations, and other criteria that under Nevada law. So that's the type of security services that this definition is talking about. Sometimes we will see private paramilitary organizations that actually in public provide security for public businesses or for at demonstrations and sometimes at political rallies and things like that. That is the kind of thing that has to be licensed, and that is the kind of activity that would be prohibited under this bill, but not, a rancher, as you say, protecting their own property. There is that right to defense of your own property on your property.
And Erica Roth, for the record, I think a really good example of this we can see, for example, let's say there's an unnamed rancher in the state of Nevada who is just patrolling their property and making sure it's safe. That's fine. That does not fall under this chapter. If that same unnamed rancher, who may or may not have actually existed, starts to actually form a militia on his property for the purpose of anti-government work, then that falls under this category. And so we can see, and we have real life examples here in this state of the difference between protection of personal property and anti-government activity.
Would it be possible to maybe state that in the bill as a very specific exclusion, that it does not include XYZ activities? That way it's very clear, because I understand what your intent is, but I'm not sure that this doesn't sweep too broadly.
Erica Roth, for the record, I think we're more than happy to look at language. This is based on model language, and to me, reading this, it's very clear what falls under it, practicing criminal law. That being said, we're more than happy to engage stakeholders and, find some common ground.
Thank you. Our next question is from Assemblymember LaRue Hatch.
Thank you, Chair, and thank you for answering our questions. As someone who grew up on a ranch with guns, patrolling property, I don't know that anything I ever did with my family would be considered paramilitary activity, but I certainly appreciate that my colleagues looking out for ranchers. With that said, I just want to clarify, the behavior that we are targeting here is already illegal, correct? Paramilitary organizations are already illegal under Nevada law. So this is just clarifying maybe some examples of behavior that the Attorney General can investigate for what is already illegal. Is that correct?
Erica Roth, for the record, that's correct.
Thank you. Yes, please.
Yeah, thank you, Mary McCord, for the record. As you indicated, Assembly Member, there is no authorized paramilitary activity currently under law, but I think the difference here, the gap that this fills, is there's no effective civil enforcement mechanism. Criminal enforcement is a blunt tool and is not as effective in actually sort of prohibiting this activity because it is about after the fact holding someone accountable under the criminal law. And so this really seeks to provide a more useful mechanism to ensure public safety and participation in democratic processes.
Thank you for that. Our next question is from Assemblywoman Hanson.
Thank you, Chair. Good morning, and thank you for being here. My question is in regards to when we talk about, you were saying on private, it might not be an issue, but we have churches that might have armed congregants that are part of a security detail for the churches or synagogues or mosques. How would this apply? Because those are public gatherings. How would this apply?
Well, I guess first, excuse me.
Go ahead, Professor.
Thank you, Mary McCord, for the record. Those type of security services would probably need to be licensed, as I understand the law in Nevada, although I am not an expert in Nevada law, and it's something to be looked into. And there is an exception here for any state authorized security services.
And Erica Roth, for the record, just to follow up on that, again, this is talking about very clear paramilitary activity. So if you have a gathering at a church and you either have lawful carry or open carry, that does not fall under this statute because it is not for the purpose. There's not a control structure. It's not for an unlawful purpose. So you can attend a church gathering, barbecue, whatever it is, people can still lawfully carry, and it would not fall under this.
You're asking for a follow-up? Go ahead.
Thank you, Chair, for the follow-up. I should have probably explained better. There are groups of already licensed concealed weapons permit holders that might be part of a church organization that do train to make sure that they're doing their security in a voluntary security for the church and its members. So that's my concern, is they're going to be scooped into this net that they are gathering in more than 2 or 3 people to do training to make sure they're using their weapons properly in different scenarios that have been already mentioned. And so how would this protect them from being scooped up into paramilitary?
Erica Roth, for the record, and I apologize through you, Chair, if I may go direct. Thank you. Thank you for the question. The existing law, the law already exists regarding security services. So this is separate from whether or not that church is acting according to law. If they're not, it's possible that they could fall under this, but the law already exists as to what they are allowed to provide under those security services. So I can't speak to whether or not that hypothetical church is doing that lawfully, but that is separate from this bill.
Okay, and I just want to put on the record in response to that question and this bill. What I'm getting from legal right now, Ms. O'Krent is not physically with us, but she is still with us, right? And just again, that this is about the actual behaviors and actions that would be deemed unlawful. So whether or not that group is associated with a church or any other type of organization, if that type of structure is happening within another organization, they still won't be shielded from investigation. And with that, we'll go on to our next question from Assemblymember Moore.
Thank you, Chair, and thank you for the presentation. during the presentation, you mentioned that other states already have this. Can you remind us how many states already have it?
Yes, Mary McCord, for the record. So every state has some sort of prohibition on private paramilitary activity. Almost every state, 48, including Nevada, their constitution sort of bakes into it that the military must be subordinate to the civilian government. That's been interpreted historically to mean no rogue sort of militias that don't answer to the governor. 30 states have anti-militia laws that are like the one in Nevada, existing in Nevada, but those are criminal prohibitions. More than 25 states have anti-paramilitary activity bills that are criminal prohibitions. A number of states, including Nevada, have laws that criminally prohibit the false assumption of the duties or functions of law enforcement or security. So every state has one of these. In terms of another bill just like this that provides these civil remedies, this was passed in Oregon in late 2023, went into effect last year in 2024. And there are some other states who have reached out about introducing similar legislation. In addition, last January, members of the House and Senate of the US Congress introduced a similar bill that would have civil enforcement mechanisms that did not make it through Congress last year. But the civil mechanism, this is something that more states are starting to become interested in for the reasons I indicated before. The criminal law is not the most effective tool here.
Thank you for that answer. I have a follow-up. So you said there's other states that are reaching out regarding doing similar legislation like this one. Are you able to share with us how many other states are looking into doing similar legislation like this bill?
So what I would say is that 2 states last year, Vermont and Maine, actually passed bills that are not exactly like this, but they were bills that added a civil enforcement mechanism to their existing criminal anti-paramilitary activity bill. And that is something I testified, I think, in both of those state legislatures as they were considering that. Last year, or maybe it was the year before, pardon me, my memory, New Mexico introduced a bill like this. They have a very, very short session, and they didn't even meet last year. So that session, it was not able to get through. It passed out of committee, but was not able to get a chance to get on the floor. And then the other states that haven't yet introduced, I feel like I should probably not talk about those publicly because they have not been introduced publicly.
Thank you so much. We will return to Assemblymember Gray.
Thank you, Madam Chair. Thinking back a few years ago to the peaceful demonstrations that were going on, there was a credible threat that came in that some of our statues and memorials on the Capitol grounds were going to be defaced or destroyed. Bunch of veterans, law enforcement, retired law enforcement, they decided to, help out. They went out and they were patrolling. They were never asked to leave, and they were tacitly approved by the sheriff to be out there. He would actually come out and meet with them every day and see how things were going. And would that be something that would be considered? I mean, they were pretty heavily armed, and they made their presence known that nobody was going to mess with those memorials. Law enforcement was overburdened at that time.
Assemblymember Roth, did you want to address that?
No, you can address that. Thank you.
Thank you. Mary McCord, for the record. So as I indicated before, there are already state licensure requirements for organizations that provide security services. So it's not clear to me that loose organization of individuals would have been in compliance with existing law. I do think that is the type, I applaud that there are people who are veterans and law enforcement officers wanting to volunteer for this duty. But if they are organizing themselves as a security service unit in public and engaging in the duties of law enforcement, which it appears they may have been, they would need to be authorized by the state, and that may or may not, under state law, include authorization by the sheriff. I would have to look into the details of your sheriff's authorities under Nevada law, because that varies from state to state.
Thank you for that. Our final question will be from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you for answering all of our many questions this morning. I'm hearing a trend from colleagues that there's a fear that people may accidentally fall into this category and accidentally get wrapped up in this. But I just want to clarify if I'm reading this correctly. It says that you're really only going to get wrapped up in this issue if you are acting knowingly as part of a private paramilitary organization or in furtherance of an objective of a private paramilitary organization. And then it lists things, right, like publicly engaging in conduct to cause physical injury or death, interfering with operations of a governmental entity, assuming the functions of government. I just wonder, in these other states, are there a bunch of folks that are accidentally getting wrapped up in this statute, or is it applied more specifically to these groups that are already engaging in behavior that's illegal?
If I may, Mary McCord, for the record, I think it would be very difficult to accidentally fall within this for the reasons you indicated. And this was very purposefully drafted to be very specific about the conduct, the actions that do threaten public safety, they threaten law enforcement, and they threaten people's ability to engage in their constitutionally protected rights under state constitution and the U.S. Constitution. And so we have not seen, again, not every state has, not that many states have this civil enforcement mechanism yet. We have not seen any sort of people accidentally falling within that. And of course, they could, make any defense to an investigation that they thought was that was available to them. What we have seen, I think, out of Oregon, at least in conversation with legislators there and the Oregon Department of Justice, is that it has caused some of the paramilitary organizations, the private organizations that had been engaging in a lot of public use of force and portraying use of force against others and intimidation and threats against others, it has seen them thinking twice about engaging in that activity, which has been beneficial to public safety. Again, ideologically neutral, no matter who it is that is wanting to engage in that activity.
Thank you so much. With that, I will go ahead and open it up for testimony. We will first start here in Carson City, and let me provide the member ID for anyone wishing to call in today. The phone number is 1-888-475-4499. The member ID is 821-9139-8612. So again, we ask anyone wishing to testify that you speak specifically to the bill and that you state your name and spell it so we have it correct for the record, and please keep your comments to 2 minutes each. So beginning here in Carson City.
Anthony Shafton in support, ANTHONY-SHAFTON. I testify today from personal experience. Because I've been a rally marshal in Reno, Nevada since 2017. I've been involved in protecting peaceful demonstrators from intimidation by groups of men uniformed and armed. This is my second time testifying before this committee about a militia bill. I testified last session in support, or I tried to be in support of Horrigy's bill, which lacked civil penalties, and I made that point during my comments. And the chair brought me up short and said that I could not make suggestions against the bill in support. But that is not an issue in today's bill. AB 119, as I understand it, makes no changes to the statutes regarding the activities deemed criminal, or if it does, it simply refines them. It only adds civil penalties for the same acts. And it is, as pointed out, nonpartisan in that it applies to illegal activity from people of any persuasion. Some members worry about infringement on free speech of counter-protesters. That really cannot be the case, for it only adds civil penalties for the very acts that are presently deemed illegal. And the same is the case regarding open carry. That right does not extend to the activities illegal under current Nevada revised statutes. Civil penalties are important historically, because historically it's been, as Mary McCord pointed out, an extremely blunt weapon, and actually has not been applied in this state.
Sir, so you did follow the rules of testimony today,
Thank
but
you.
this time you're over time. So, thank you so much for your testimony. If you have any additional comments, you can submit them by mail or email. Anyone else wishing to testify here in Carson City? Is there anyone there in Las Vegas? I'm not sure if there's anyone there. So, broadcasting, please open the lines.
If you would like to testify in support of Assembly Bill 119, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of Assembly Bill 119, please press star 9 on your phone now. Chair, there are no callers wishing to testify in support at this time.
Thank you. Then I'll open it up for opposition testimony. If there's anyone wishing to oppose here in Carson City? Broadcasting, will you open the lines?
If you would like to testify in opposition to Assembly Bill 119, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in opposition at this time.
Thank you. Then I will open it up for neutral testimony. Anyone wishing to testify in neutral?
Morning, Chair Miller, members of the committee. Michael Morton, Special Assistant Attorney General with the Attorney General's Office. Testifying in neutral today to the bill. We've been in contact with the bill sponsor and spoke with her yesterday about what exactly the jurisdiction looks like for the Attorney General's Office for investigatory purposes and working with other state agencies that also might have jurisdiction through these investigatory measures if they ever to arise.
Thank you so much. Is there anyone else here in Carson City wishing to testify in neutral? Broadcasting, will you open the lines?
If you would like to testify in neutral for Assembly Bill 119, please press star 9 now to take your place in the queue.
Good morning, Chair. Good morning, Assembly members. Jason Gibson with the House of Gibson. I'm going to speak directly in neutrality to this bill, but before doing so, I'd like to provide a context for my testimony without interruption. Thank you. We were very much present for the riots in Portland with the Proud Boys and the collusion that we discovered between Portland police and the Proud Boys. We have also been monitoring social dynamics and megatrends in this country for well over 30 years on behalf of the Foundation for the Law of Crime, Natural Law Peace Initiative of 1935 under the direct tutelage of Drs. Jose and Ladine Arguelles. And we are here to remind you that there were law enforcement and paramilitary members of the armed services involved in our insurrection. As a 40-year resident of Douglas County, Nevada, what we have here is, well, we've got a question for this committee, and what happens when local law enforcement doesn't follow the Constitution? What happens when the state doesn't uphold the Constitution or teach the Constitution? Well, you get more bills and more legislation like this, because there's been a wholesale abandonment of our constitutional peace of mind. So therefore, and to give you a good example of the private paramilitary activities of Douglas County sheriffs, they're flying a foreign flag in violation of the flag code at both entrances of the jail facility. None of those officers honor the Constitution or can tell you how many articles are in it. So when they're training with all of their weaponries and they're not following the Constitution and there's no way of auditing the authorities, then what you have are paramilitary groups who are training to defend themselves against the municipalities that are supposed to be protecting us. In the 40 years that we've been here, we've never had the equality of justice extended to this house, ever, and we're paying for it. And that's why you have this bill before you today. Thank you.
Thank you. Next caller?
Chair, there are no other callers to testify in neutral at this time.
Okay, thank you. Then I will invite the bill presenter back up for any final remarks.
Thank you, Chair. Erica Roth for the record. Just very briefly, I want to thank Professor McCord for her time this morning. And just in sum, this bill does not create any new crimes. It's a civil enforcement mechanism to ensure that we are able to intervene when these paramilitary activities are taking place. And that's it. All right. Thank you so much.
Thank you so much. I will go ahead and close the hearing on Assembly Bill 119. And we're going to take a moment because we're going to switch out. Vice Chair Marzola is going to take over.
We will now be back to order. I will now open the hearing on Assembly Bill 227, which revises provisions governing adoption. Chair, when you're ready.
Thank you, Vice Chair Marzola, and good morning again to my fellow judiciary members. For the record, I am Brittany Miller, representing Assembly District 5. I am sponsoring Assembly Bill 227, which aligns, streamlines, and organizes Nevada's adoption laws. This bill attempts to add consistency to what can be a very lengthy, cumbersome, and even expensive, financially expensive process. While I am no means the expert on adoption laws, I am a witness to and a supporter of the miracle of adoption. So, of course, I was delighted when Ms. Kim Surratt asked me to sponsor this bill, especially because of its potential to really help our Nevadans through this process. With that, I will hand the hearing over to Ms. Surratt, who will go through her experience. And just for the record, I want everyone to know that she spent over a year working on this very cumbersome and technical bill. So with that, Ms. Surratt.
Thank you very much. Thank you, Vice Chair. Thank you, Chair. Kimberly Surratt for the record. My last name is Surratt. I have been a family law attorney, private practice in Northern Nevada for, I hate saying it now, 23 years. So, and I have helped construct a lot of legislation in this building. From the family law perspective, a lot of times it's out of complete frustration that our chapters are just really difficult for us to work under. We don't have good instruction in them, our procedures are missing, and that's exactly the circumstance with the adoption chapter. We knew that at some point in time we had to just roll up our sleeves, dig in, and just actually make it happen. In the process, this bill came together working with a lot of stakeholders in the state. The goal and intent is to do what everybody wants or needs with this bill, to be really blunt, so I am all ears. The mechanism that came out in drafting was not quite on the mark. We had a lot of stakeholders buy into the exact language that I proposed. And looking at the type of edits that needed to be done, it needed to be a gut and replace with the original language that everybody had seen in prior renditions while we worked with the stakeholders. That is the conceptual amendment, is to just go back to the original language that we requested. There will be a few changes. One would be that the way I drafted it, I made it look like we needed 2 adoption registers. We do not. We only need the 1. It just was a flaw in the way the drafting came out. But 1 register, which should take away the unfunded mandate on the bill, because we already have a register. In the process, we realized that instead of 1 chapter, we really needed a couple of chapters. And so it has now been divided into the private adoption world in one chapter, which is at the time, right now, I'm using for the purpose the original adoption chapter language, which is chapter 127, edited for private adoptions. We created a 127A for adoptions of children in the custody of child welfare agencies. They have a very different procedural process than private adoptions. Part of that is the child is already in the care of the child welfare agency, and steps and procedures are different at that point in time. Their control and ability to choose adoptive parents is different. Their timing with everything is very different. So we created a separate chapter just for those adoptions. And then we created a new chapter, 127B, also for the Interstate Compact on Placement of Children. That is a verbatim movement of that language into its own chapter. There is future plans and hope to work deeper on this chapter in some more substantive changes in the state that we need in adoption. And there is a movement across the country for an updated version of the Interstate Compact on Placement of Children. It was a point of exhaustion where we got to with just doing procedural cleanup that we didn't get to the point of even discussing what to do with that language yet. So the hope is in future sessions we will dive even deeper and bring you the things. A lot of people may say to you, well, adoption needs to be fixed. I agree, there's a lot of things that still need to be fixed, but if we can't get where we procedurally can follow it first with this amendment, then it gets harder to even get into those substantive changes. A gigantic part of this amendment, and I have one whole page of it, is just where we made the language align. So these are all references within it of just aligning and using the exact same language, using fewer words when we could, really cleaning up the language. One of the prime examples of that in the chapter is the usage of the words relinquishment and specific consent. Relinquishments are very much so used in the child welfare agency world. They're also used in the private world. The difference is with a specific consent, I'm specifically choosing a family who I want to place my child with, and that has different ramifications in the type of consent that I'm signing. From a relinquishment where I give up all of my rights and that child is now in the custodial hands of the agency to do what needs to be done for the best interest of that child in the future. At some point in history, we started using the word release in the chapter. None of us know what that is. We don't use that terminology. It's not in our mechanism, so we got rid of that word. Now, with consents, like I said, that has a very purposeful meaning. I'm signing a consent to give up my parental rights. But we started using the word consent also when I have a spouse that needs to consent for me to adopt, or the child is 14 years or older and needs to consent to adopt. We quit using the word consent for those because it just blurred the lines between what are we talking about, which consents are we talking about in the chapter. So we've changed the language, cleaned it up, and then we went to all of the types of adoptions we do in our state, and beyond the child welfare ones within the private adoption chapter. And there were a lot of types of adoptions that, to be blunt, we made up the procedures with the courts over time. If you knew and I told a lot of you this, if you knew the secret handshake, you knew how to do it. If you didn't, you couldn't read the chapter and know how to do it. So we have the specific agency adoptions, the close family adoptions, confirmatory adoptions, readoptions, and identified adoptions. Now, identified adoption is a new term that through all the stakeholders we decided to use. Some might call it a directed placement, but that has some other legal ramifications within the family law realm, so we didn't choose that word. So just doing that made it look like an insane mess that you all had the joy of getting to read, and I'm sorry, you probably all hate me because of the length of this bill. There were other subtle changes in substantive things with some deadlines. A lot of it had to do with it would give us a right to do something, for example, if a private agency felt that the person's rights should be given back. Maybe there was belief that there was actual coercion and duress when she signed away her rights. There was no mechanism for us. You would think the chapter would just point blank say that it was no longer valid, but it doesn't. It didn't give us the ability to go to the court and say there was coercion. We would make it up and try to convince our courts of that. But there was nothing to point to as to how to do it, that they even had the right to do it. And obviously, we don't want somebody put under coercion and duress to give up their parental rights. That's not the goal in adoptions. Some of the other big substantive changes, we deleted things in the chapter that upon confirming with Clark County and Washoe County primarily, there were parts in the chapter where it talked about things that none of us knew what they were. We were like, do you do that? Do you do that? No. Does the county do it? No. Everybody said, well, I don't know why it's in there. We've never done that. And so, there really is a bigger fine line behind the private adoptions, the agencies that are licensed there in that realm, and what Child Welfare Services does. And because the chapter was blurred together before, it kind of made it sound like you were supposed to do these things for private within the child welfare world or vice versa, and it wasn't clear. So we've cleaned up all of that. There was discussions in the building in the past 2 days with the Clark County Public Defender's Office. There are sanctions in our chapter that were pre-existing sanctions, criminal sanctions for things such as illegal matching of children if you're not a licensed agency, and advertising's a hot topic in the country right now, that if you are not a licensed adoption agency, there's a lot of what we call facilitators in the country who will very intentionally go in and illegally advertise and make people believe they're working with a licensed agency when they're not. We actually have a pretty limited number of licensed agencies that meet all the rules in the state of Nevada. And so our statutes, we had put in felony D because it matched other sections of the chapter that said felony D. The Clark County Public Defender's Office would like to change it to a felony E. I'm okay with that. I'm not a criminal attorney. I'll be really blunt with all of you. I don't even know the difference between D and E. I was just making it match in the chapter. So we're good with that. We will change it. I did follow up with the Attorney General, and because part of the issue is we're having trouble with enforcement of those advertising rules. They're mostly interstate crimes. Very few people, they're going across state lines to commit these crimes. And I was just told, you pick it, I'll enforce it. So basically, doesn't matter. Other than that, there is, of course, a lot of instability in the room because it's not the actual language in the bill yet. It's the conceptual amendment, but we really did work really hard with private agencies, private adoption attorneys to get to where we are with this bill. If you have specific questions about specific substantive things, like I said, there's not a lot of the substantive ones, but I'm here for you and happy to answer it, because I don't think you want me going through the whole thing.
We're ready for questions. Thank you, and thank you for your presentation today. We will start with Assembly Member Nadeem.
Thank you, Madam Vice Chair, and thank you for the presentation. My question is regarding the private adoption section. So can you give us some example how this bill improves the process and makes it more secure?
Yes, absolutely. Kim Surratt for the record. The question is regarding making the private adoption process more secure. A family law attorney's nightmare is that we don't have written in a statute procedurally what to do. You walk into the courtroom and you find out from the judge they have a different interpretation of the procedures and these silent procedures that exist out in the world. So that is a big part of the problem. If you do know how to do an adoption, you can, but new practitioners coming into the world or private citizens can't pick up this chapter right now and say, oh, that's what I need to adopt a child. They can't do that. It's impossible to read the chapter that way. So it will assist a lot of people in having clean, clear procedural requirements, knowing exactly what they are, going type procedures, and going to that list, complying with it, and hopefully not having surprises. I think in the future, we're going to have to make some more detailed changes on some of the timelines and things that people complain about. But until we get to clean procedures, we don't know what timelines to approach.
Thank you.
Committee members, any other questions? Assemblymember Cole.
I have just one question. I think this is an amazing thing that you're doing. Everything that I know of with the law is you can't obey the law if you don't know what it is. So making it clearer and easier to understand is much better. My only question is, can you just give, and it doesn't have to be today, it can be in writing, just what are the substantive changes that you're making? Because I know that most of this, like 80%, 90% is procedural, just whatever is substantive. Thank you.
Yes, Madam Vice Chair. I didn't ask if I could go direct earlier. I'm sorry.
No problem
You
at
think
all.
after 20 years of being in the building, I could. Kimberly Surratt.
Go ahead. Go direct.
Yes, absolutely, I can. Some of them are real subtle, so it's we've started it. We're at about 6 pages of just little tiny things, like I said, and just the aligning of the language. If you're okay with it, I'll leave out the alignment of the language list and get it as clean and narrow as I can for the committee members. Okay.
Committee members, any additional questions? I don't see any. I do have a quick question. How many licensed adoption agencies do we have in our state?
Kim Surratt, for the record,
if you have that information.
I could dig it out of my computer. When I come up for follow-up, I'll tell you exactly, but it's not very many. It's not enough. This has nothing to do with this bill. It's not enough, but there's some major changes that need to be done in the NACs to make that process more streamlined. I'm going to give kind of a passionate example. Catholic Charities in Reno used to run an adoption agency for quite a few years, actually a lot of years, decades. And with COVID and with different things, like their program, they lost their director and they shut down. They would like to reopen. There is a really ridiculous administrative code regarding the amount of time a social worker has to have adoption experience. With so few agencies, there's not enough people with that amount of experience for them to reopen. Sorry, that's a soapbox, but there's so much more we need to do in the adoption chapter. We're not there yet. I just need to get everybody aligned on this, and then we can keep going, hopefully. So.
No, and I appreciate your response. It's a very, very important subject matter in our state, so I appreciate you being here and also the presentation. So I'll give you
And Vice Chair, I would
Go
just
ahead,
like
Chair.
to add to something of that. The challenge too, when Ms. Surratt spoke about the challenges with trying to communicate with other states, all of us know or are part of families where adoption has happened, right? And I think of my friends where adopting children, each different state was a different set of rules, including one child they could bring home from the hospital within 3 days. One child from another state, they physically had to stay within that state for 6 weeks. So that meant 6 weeks where mom and new infant were in a hotel room by themselves when husband had to come back to work, and it's just those challenges as well as any of us talking about the financial cost that and the years that it takes. And so anything that can help, just families in general, people adopting in general, especially within the states, would be helpful. So we're proud of them. Right?
Yes, we are. Thank you, Chair, for that response. We will start testimony in support. Is there anyone here in Carson City wishing to testify in support to Assembly Bill 227? Please remember to state and spell your name for the record. You each will have 2 minutes. You may begin when you're ready.
Good morning, Melissa Exline, E-X-L-I-N-E. I'm an attorney at Surratt Law Practice, and I have the good fortune of working with Kim Surratt. My area of practice related to the adoption arena is slightly different than hers. I have litigated when there have been very contentious issues where a parent may be trying, a natural birth parent may be trying to get their child back after some very complex circumstances. And what I have found in those types of situations is I've gone to the statute and then I've tried to figure out what are we supposed to do? And then I go to Kim and I look at the law and I'm like, what's going on here? Why is the law written this way? You can't figure anything out. And I'm like, how do you practice this area of law? And so to that end, I would point out things that I found so remarkably difficult and confusing. Ms. Surratt touched on a couple of them. I just want to highlight those very briefly for you to just show you how much, how important this is and how much it's needed. The issue of rogue words like the word release just thrown in the statute and being utilized also within case law. You think you know what that means, and then they are using different words like a consent and a relinquishment. Consent being to a specific family. I'm giving consent for this person to adopt my child, or I'm giving consent for this, or a relinquishment for this agency to place my child with any family of their choosing. There are situations where when we go to figure out what to do with these families, we don't know how to undo things. This will address just the general issues by having clearer language will give people a better mechanism to know what to do. Adoption shouldn't be something that can be just undone willy-nilly, and I'm not a proponent of that. But I am there to look at the law and make sure that everyone's rights were enforced and everything was done on the up and up. I want to point out too that this statutory change, while it's a big cleanup, is also doing something fundamentally important in my opinion. It is addressing an equal protection issue. Birth parents, fathers and mothers were treated differently in when they gave up their rights, whether by a consent or a relinquishment. A father had the ability for his document to become invalid, so his parental rights were restored or retained, whereby a mother, a birth parent, once she signed a document, and I'll call it generally a document because the names were used differently.
I hate to interrupt you. If I can have you wrap up your comments, please.
Thank you. All that to say is this is cleaning up those issues with parents being treated differently. So thank you for your time and support.
Good morning, Vice Chair and members of the Judiciary Committee. My name is Shelley Cooley. I am an attorney in Clark County, Nevada. I've been practicing for, we'll just say a couple decades. We don't have to get more specific than that. I helped with this bill, and I absolutely support the conceptual amendments to the bill. We worked with all the different stakeholders to get language that we all agreed upon. And a lot of what you see as far as the changes go are just language cleanup. Our statutes use natural parent. We don't know what that means. There's no definition. So in our original adoption statutes, we have 3 definitions. And in our new adoption statutes, in the conceptual amendment, we have 37. So it really is trying to give the public and attorneys and the division clear guidelines as to what we need to do so that we can finalize adoptions and get kids into their forever families. So
Thank you for your testimony today.
Good morning, Vice Chair Marzola and members of the Assembly Judiciary. I am Bridget Duffy, Brigid, Duffy. I am here to support the conceptual amendment today on behalf of Clark County Family Services. Half of my position in my role as Assistant District Attorney is a supervision of 21 Deputy District Attorneys who oversee and represent cases in Family Services jurisdiction. We worked with the sponsor during the interim to come up with the language, and we thank Ms. Surratt for her years of work to improve our family court system. The conceptual amendments would be the language that we worked on during the interim. Specifically as to that new section of 127A, we believe that it will streamline cases of children that are in foster care and heading into adoptive homes. And really because a child that is removed from a home and placed into foster care has constant oversight of the judiciary, tons of reviews, like at least every 6 months. So there are a lot of things that we can streamline that we don't need in basic general adoptions. Thank you very much for your time.
Thank you for your testimony today. Is there anyone else here in Carson City wishing to testify in support? I don't see any. I don't see anyone in Las Vegas. AVH, is there anyone on the line?
If you would like to testify in support of Assembly Bill 227, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of Assembly Bill 227, please press star 9 now.
Good morning. My name is Chandler Cooks, ChandlerCooks. I'm here full support of AB 227, a bill that puts children first and makes Nevada's adoption system faster, fairer, and more compassionate. This bill breaks down barriers that have kept too many children from finding homes, safe, loving homes. And this introduces reforms that are thoughtful, necessary, and deeply impactful, reforms that prioritize the well-being of children, improve the efficiency of the adoption process, and offer stronger post-adoption support for families. This makes it easier for families to provide stability to children who need it most. This bill is about one thing: giving every child a real chance at family, stability, and a brighter future. Thank you so much to Assemblywoman Miller for bringing this bill forward, and I urge you to support AB 227 and make that future possible. Thank you.
Chair, there are no other callers to testify in support at this time.
Thank you. We will move to testimony in opposition to Assembly Bill 227. Is there anyone here in Carson City wishing to testify in opposition? Please remember to state and spell your name for the record. You may begin when you're ready. I need you to press on your mic, please. Thank you. Can you
morning.
start over?
Yes, Stacy Lance. It's STACEY, and I'm a division director at Washoe County Human Services. And I just want to start by saying I'm up here in opposition only to the bill as it came out. I'm in full support of everything that has been explained. That this is very needed for child welfare and for 127A. Ms. Surratt has done so much work on this, and we were a part of it. We agree completely with the draft that was submitted, and we plan to continue to partner and be part of this process. So thank you so much.
Thank you for your testimony. Is there anyone else wishing to testify in opposition? I still don't see anyone in Las Vegas. AVH, is there anyone on the line?
If you would like to testify in opposition to Assembly Bill 227, please press star 9 now to take your place in the queue. Vice Chair, there are no callers wishing to testify in opposition at this time.
Thank you. We will move to neutral testimony. Is there anyone here in Carson City wishing to testify in neutral to Assembly Bill 227? Don't see anyone coming up. There's still no one in Las Vegas. AVH, is there anyone on the line?
If you would like to testify in neutral for Assembly Bill 227, please press star 9 now to take your place in the queue. There are no callers wishing to testify in neutral at this time.
Thank you. Chair, would you like to give any closing remarks? I see the heads nodding no. I will now close the hearing on Assembly Bill 227. 1 minute recess.
Okay, as we come back to order, I would like to open up the hearing for Assembly Bill 351. Assembly Bill 351 revises provisions relating to the jurisdiction of juvenile courts over certain offenses. And so with that, it's good to see you up here in Carson City. I think this is the first time this session you've been up here.
It is, Chair Miller, and I have to say I'm really happy to be here.
We're happy you're here as well.
And it's my first bill presentation, but I brought a partner with me. So for the record, I am Bridget Duffy, Brigid, Duffy. I, again, am still the Assistant District Attorney for the Juvenile Division of Clark County, and I am testifying today on behalf of the Nevada District Attorneys Association to introduce Assembly Bill 351. I'm going to just quickly walk through the bill because it's really just one section, and then I'm going to pass it over to my Chief Deputy DA, Michael Watson, who's here with me, to kind of run through what this actually means for the state of Nevada, because the language is a little odd how it's written. Section 1 amends 62B 335, and this would require a hearing to determine if there is probable cause to believe that a person committed a delinquent act that would be a Category A or B felony. So this is for two categories of people. The first category are 16 to 18-year-olds, where we file the petition, which in juvenile court is our charging document. We call them petitions. And we file that petition before the person turned 21. And after that petition is filed, a writ is issued. And a writ in the world is more commonly known as a warrant, but in juvenile court, we call them writs. So that writ is issued but not served until after the child turns 21. The second category of people are those that are under the age of 16, where we again file the charging document, the petition. That writ or warrant is again issued by a judge and not served until after the person is 21, or we have not identified the person before they turn 21. So that would be, we have a crime, we have no idea who did it, but then somehow, some way after they turn 21, and Chief DA Watson will get into that, we find out that they are the person who had committed the Cat A or B felony. So now I'm going to turn it over to Chief DA Watson to run through some scenarios with you.
Thank you. My name is Michael Watson, MICHAELWATSON, and I'm a Chief Deputy District Attorney in the Juvenile Division of the Clark County District Attorney's Office. As our law stands today, a juvenile can literally get away with murder in the state of Nevada. This bill will help close those jurisdictional gaps so that type of thing doesn't happen anymore. There's a lot of qualifiers and a lot of different statutes at play, so it gets a little complicated. So I'm going to present some examples and scenarios so you would understand what type of things would now qualify for at least a judicial review. So the first example that I would present you with is a 15-year-old, and we can say this person's 15-year-old and 364 days old, the day before their 16th birthday. They commit a murder in our state, and let's say that they're able to be identified. We know the person who did it, but they're able to flee our jurisdiction, flee the state, flee the country with either the help of their family or a gang, or for whatever reason, law enforcement is just unable to locate and identify this person. They can return to the state of Nevada, return to the country, come out of hiding at age 21, and no court has jurisdiction. There's no way to hold them accountable under our current law. The second scenario that I present you with is a 14-year-old commits a violent sexual assault. Let's say this person's wearing a mask when this happens, and we're unable to identify them for that purpose, or for that reason. Let's say that DNA and fingerprints are collected, but there is no match in order to identify the person. And with juveniles, DNA doesn't go into a database, and fingerprints don't go into APHIS, so there isn't a national searchable way to match those. And then later, this person turns 21 and does something where their DNA is now in a database, and we're able to identify that person. We're still not able to hold them accountable. We have to call the victim and say, we've been able to identify the person who sexually assaulted you, but we can't do anything about it because they're now 21. And then the final example I leave you with is a scenario that our office has dealt with. Multiple juveniles take a person, hold him at gunpoint, kidnap him, hold him for hours, and transfer approximately $4 million in currency. They later take him across state lines, drop him in the desert, and in this case, law enforcement's able to find and identify these people, and we're able to get writs or warrants issued for their arrest. As soon as one of those juveniles was picked up, the others were on notice that we knew who they were. And one juvenile flees the country with his family. They go to a country that doesn't extradite. And in this particular example, this person happens to be 16, but let's say they weren't. Let's say they were 15. They could now come back into the country at age 21 and would be free. We could not hold them accountable. When the bill was originally passed that created 62B 330 in 2009, that was a gap bill to close the gaps that existed at that time. We've made some other changes during the years that have created some new gaps now. And then the Supreme Court has come out with more recent decisions that have increased those gaps. So that's why we bring this bill. And, you know, all these scenarios, they do happen. We deal with 15-year-old murderers. We deal with murderers that are younger than that. We've had 2 in the last year that were 12. We deal with sexual assaults at age 14, and we deal with sophisticated robberies and kidnappings with juveniles. Now, granted, it's not a large number of cases, but they are cases that we deal with. This bill would not allow that to happen without at least having a judicial review. And that's the other part I want to highlight. This doesn't automatically put a case into the adult system. What this bill does is create a review by the juvenile court to look at the case, first determining whether there's probable cause to move forward, if we have enough evidence to move forward. And then once that's determined, we move into another analysis where the court will look at the gravity and nature of the offenses, the effect that it had on the victim, and then weigh that against any of the prior history they may have had or history after the fact, looking at also any counseling services, any punishment they may have received in the past, and also just looking at generally what this person has done since this time period has passed, essentially determining whether this person has become a productive citizen and make a determination as whether this case should move forward to the adult system or just be outright dismissed. But the important thing is we at least have the ability to bring it to a court and have a review. Thank you.
We'll be happy to take any questions that you have.
Thank you so much for that. Our first question is from Assemblymember Roth.
Thank you so much, Chair, and thank you so much for the presentation. I just want to make sure I understand this. So please correct me if I'm wrong. If an individual commits an A or B felony when they're under the age of 18, if they were to abscond and then be caught at a later date after they're 21, under the current law, are they currently adjudicated under the adult system or the juvenile system?
Michael Watson for the record. So if they are under the age of 16, they are not able to be adjudicated at all at this point. If they are 16 or 17 with the current law that's 335, we have the same judicial review. That's already in the statute. So they would start in the juvenile system and the court would determine if we go to the adult system or if the case is dismissed.
How many cases fall under that where they could not be adjudicated?
I can't give you an exact number, especially under 16. I do know that since we've had this law in place since 2009, I started in the juvenile division in 2010, and to the best of my recollection, I've probably had 6 or so of these cases that we've had to bring to a court to determine to move it forward. So I don't think it would be a large number.
The question is in regards to how many could not be prosecuted at all.
Bridget Duffy for the record, still Assemblymember Roth. Part of the reason we're bringing this bill is because the Supreme Court issued a decision, and I'm sorry, I can't remember off the top of my head how long ago it was. It was, I want to say 2 years ago, because we tried, the session was starting 2 years ago, and I was trying to get this gap filled, but bills had already been dropped and I couldn't find a place to put it. I know you all understand that. So it's probably been about 2 years. There were 2 cases in Nevada. One of them is Barron, where the Supreme Court said some court has to have jurisdiction. So you can't just say somebody gets away with murder or somebody gets away with, felony sex assaults. Somebody has to have jurisdiction. So prior to 2021, anytime a child was picked, now a young adult was being picked up and brought in for something they committed before the age of 16, we dismissed the juvenile case, and then the criminal DA's office would determine whether or not to file it, because according to the case law in Nevada at that time, somebody had to have jurisdiction. I hope that makes sense. So then the Supreme Court, a Justice Hardesty ruling on a case where a child was 14 at the time they committed a sex assault and actually had left the country with their family, was brought back, and then ultimately, after 21, we had, again, used that same position where we dismissed the juvenile case, let the criminal case resolve it, and the RDAs in the criminal division filed it. They determined that they negotiated it to probation with the public defender, but the judge then would not go with the negotiated sentence and actually committed the child, well, now young adult, to prison for an offense that was committed when they were 14, despite the negotiations of the DA's office and the public defender. That case was then determined by the Supreme Court in, I'm just guessing, so about 2021, because I remember trying to get this jurisdictional gap filled, said, no, because he was a juvenile, it should have started in juvenile court, and this criminal court doesn't have jurisdiction over it because he turned 21. That created the gap. And so luckily, we have not had that case that we are holding our breath to get, where that 364-day kid is given the gun by the gang member to kill somebody because they're a juvenile. They can hide out and get away with it after they turn 21. We haven't had that yet. But that's why we're coming to you today to fill the gap. We're not asking that these kids go right to criminal because they were juveniles when they committed it, if they had been identified, even if I go so far to say that even if they hadn't been manipulated by the gang member to do it and then hid out somewhere until they were 21, they still get the right to go in front of the juvenile court, where the juvenile court will decide whether or not justice involves them having to face this charge in the criminal court system under a whole series of factors that already exist in law, plus the probable cause hearing. And, we get to tell victims, hey, we identified them, and you can come to the juvenile court hearing and see what happens. So I can't really tell you how many we've had, because before that Supreme Court decision, we were just dismissing cases, sending them to criminal. Criminal will decide whether or not to file the charge. So I hope that settles everything and answers your question.
Thank you so much. And thank you for explaining that, because I know it's difficult for folks to understand the different scenarios. Our next question is from Assemblywoman LaRue Hatch.
Thank you, Chair. Thank you for being here this morning. Just for those of us that are not in this world every day, can you just give us some examples of what a Category A and a Category B felony might be?
Category A felonies, murder, sex assault, kidnapping, the type of cases that could carry potential life sentences. Category B felonies, robbery with use of a deadly weapon. It does include things such as residential burglaries. We use our discretion in our office to dismiss a lot of those cases. When we've had writs out, every 6 months I get a list from our juvenile justice partners that have their list of writs, and I go through them and clean out cases that we wouldn't move forward on. So the ones that are potentially lower level, we are cleaning up ourselves using our discretion.
All right, thank you so much. Not seeing any additional questions, I will open it up for testimony beginning here in Carson City. Anyone wishing to testify on Assembly Bill 351?
Good morning, Chair Miller, Vice Chair Marzola, and members of the committee. My name is Jennifer Noble, Jennifer Noble, and I'm testifying on behalf of the Nevada District Attorneys Association in support of AB 351, which seeks to fill an important jurisdictional void. When something as serious as a sex assault or murder happens, there should be some court that has jurisdiction over that matter. Even if the court ends up ruling against the state, saying it's been too long, the case gets dismissed for other reasons, we don't want to have no court having jurisdiction over that case. And for those reasons, we urge your support of this bill. Thank you.
Good morning, Chair Miller, members of the committee. Jason Walker, JASONWALKER, representing the Washoe County Sheriff's Office, supporting Assembly Bill 351 for all the reasons outlined in the presentation.
Thank you so much. Is there anyone else here in Carson City? Not seeing anyone and not seeing anyone in Las Vegas. Broadcasting, will you open the lines?
If you would like to testify in support of Assembly Bill 351, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in support at this time.
Thank you. Then I will go ahead and open it up for opposition testimony, beginning here in Carson City.
Good morning, Chair Miller and members of the Assembly Judiciary. Paloma Guerrero, PALOMA-GUERERO, on behalf of the Clark County Public Defender's Office. If someone asked me to tell them what happened on March 8th, 2008, when I was 14, I couldn't tell you what I was doing, where I was, or who I was with. NRS 62B 335 passed in 2009 as a result of juvenile stakeholders working together to answer the question, who has jurisdiction over a person who is more than 21 years of age who committed delinquent acts as a child? There was the DA's office, the PD's office, and the Division of Family Services that came up with that proposal, and they struck that proper balance then. It gives the prosecutors the ability to pursue these very serious criminal offenses, category A or B felonies, and it gives the defense attorneys adequate time and opportunity to defend against such an action. The legislature specifically opted to only provide jurisdiction over adults who have committed those A or B felonies when they were 16 to 18 years old. They prioritized this policy for juvenile offenders who have matured into adulthood in hopes that they would leave their delinquent past behind. The case that was mentioned is Zalyaul. It's Zalyaul. It's a 2022 Nevada Supreme Court case. That case did not create a gap that this bill is trying to fill. That case rightly interpreted that 2009 statute based on the legislative intent from that time, and at that time they rightly chose not to include kids under 16. The presenters today now want absolutely no limitations to prosecute you for acts that you made as a child. Imagine being prosecuted for a crime when you were 14 years old, being the age you are now. You have to defend yourself against allegations when memories have faded, witnesses have disappeared, evidence has become stale, and records unavailable. We have limitations for very important reasons. In this example of a 13-year-old committing murder, then purposefully going into hiding for 10 years to try and avoid prosecution, and successfully evading law enforcement, they haven't had that example because it's just not real. We're talking about children here, not sophisticated and shrewd criminals. And the example of a parent taking a child out of the country, that's outside of the child's control. And now they want that law to punish the child for 8 years later.
Thank you. Your time is up. Next, please.
Good morning. Angela Knott from the Washoe County Public Defender's Office, ANGELAKNOTT. To add to my colleague's testimony, juveniles are treated differently in the justice system compared to adults. With juveniles, the justice system tends to focus more on rehabilitation so that they can rejoin society in a productive way. For adults, the focus is more on punishment. One of these reasons is because a child's decision-making, the peer pressure, and their impulse control is just different from an adult. Basically, this bill will allow the justice system to punish a 30-year-old adult in the adult system with adult punishments for a crime they committed as a juvenile when they were 15 years old. I'd like to add that 1 or 2 cases with someone who is under 16 is not a pattern that necessitates a law change. For those reasons, we cannot support this bill. Thank you.
Thank you. Is there anyone else wishing to make opposition testimony here? Not seeing anyone here or in Las Vegas. Broadcasting, will you open the lines?
If you would like to testify in opposition to Assembly Bill 351, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in opposition at this time.
Thank you so much. Then I will open it up for neutral testimony. Is there anyone here in Carson City for neutral testimony? Not seeing anyone. Broadcasting, will you open the lines?
If you would like to testify in neutral for Assembly Bill 351, please press star 9 now to take your place in the queue. There are no callers wishing to testify in neutral at this time.
Thank you. Then I will go ahead, and the bill presenter is here to make her final remarks.
Thank you, Chair Miller. Bridget Duffy, for the record. Just in response to the bill being negotiated in 2008, we have had a lot of law changes since then. One of them, with the support of the District Attorney's Office, was eliminating the direct file of children under the age of 16 directly to the adult system for murder and attempt murder. So the GAP bill that was passed originally, we didn't have concerns because if that 12, 13, 14-year-old committed murder, jurisdiction automatically lied with the criminal court. So the law has changed a lot since then. And our Supreme Court has issued mandates under case law that have created us being here today. And just please remember, even if that 30-year-old is coming back for a crime they committed, a murder they committed when they were 15, just short of 16, the juvenile court is using its discretion on a variety of factors that are already in your statute to determine if they go to criminal court or to just dismiss the case. So it's not an automatic. It's a check and balance in the system, and it's a right for victims to have that closure as to what happened. So again, thank you for this opportunity to fill this important jurisdictional gap in our law.
Thank you so much. And with that, I will go ahead and close the hearing on Assembly Bill 351. Next on our agenda today is public comment. So anyone wishing to make public comment here in Carson City? Not seeing anyone? Then broadcasting, please open the lines.
If you would like to provide public comment, please press star 9 now to take your place in the queue.
Thank you, Chair. Thank you, Assembly members. Jason Gibson on behalf of the House of Gibson, Gibson. We use this public comment to remind you that with regards to Public Law 108-447, Section 111, which was passed to raise the self-reflective intelligence of our state, I quote, each educational institution that receives federal funds for a fiscal year shall hold an educational program on the United States Constitution on September 17th of such year for the students served by the educational institution. Each federal agency or department shall provide educational and training materials concerning the United States Constitution to each employee on September 17th of each year. This is supposed to be a week-long educational reminder, an investigation of American history. We know that several institutions, municipalities throughout the state of Nevada received millions of dollars through the American Rescue Plan Act, and they are in violation of this law, this public law. And what we found when we searched for the Nevada State Constitution on YouTube is absolutely nothing. There is no educational value being offered to the general public by means of YouTube or any other social networking utility that we're aware of that actually teaches the Constitution. And for many of the elders in this state, you're reading an 11-point font. It stresses their eyes. They can't study the Constitution online because it's too taxing on their retinas. And the point is that we have a constitutional crisis in this country as a result of a lack of responsibility by our elected officials. I'll use the closing comment if I still have time to remind you that we are testifying here again today that because of the reckless practices of the state, that I spent $150,000
Thank you, sir. Your time is
for four
up.
pairings.
Thank you, sir. Your time is up.
There are no other callers to provide public comment at this time.
You're welcome. Thank you all. Whoops.